Hello, everyone. We're very glad to see each of you here. We can't name you all, of course. Barney Dean's flown all the way up from the south. A bunch of other people have come from all around, and they're all welcome. We have our problems with the construction of the school because it was constructed as a school and not as simply a lecture hall. So we had to fill up some seats that others are going to lose out on them because they weren't here on time. But that's too bad for them. And we're sorry. Now to the business at hand. And a pleasure business it is. It is my privilege and honor introducing to you someone who has been named by the New York Times as, quote, the happiest camper, unquote, on the Supreme Court. You need to spend no more than 5 minutes with her to learn the truth of the Times evaluation. The newspaper put their reasons this way. She took the bench every morning with a smile and then, by all accounts, enjoyed herself immensely. The fact is, Justice Ruth Bader Ginsburg makes happy campers of all who come her way. It is especially gratifying to note the instances in which her life has intertwined with law professors. Unable to become employed by a law firm on graduation from law school for the simple reason that she was a woman. It was a teacher who helped her get a job, albeit as a law secretary to a federal judge. Later, Justice Ginsburg became a professor at Rutgers School of Law, and then became the first woman law professor at Columbia School of Law. The American Association of Law Teachers and Time Magazine have both named her as Teacher of the Year in those years. She then spearheaded the ACLU Women's Rights Project during the 7 years while she served as general counsel to the ACLU. Winning 5 cases out of 5 in the Supreme Court, she helped establish gender equality in our laws. As proof of the breadth of her approach, many of her victories can be seen with careful reading as benefiting men just as well as women. In her response accepting the president's nomination, Justice Ginsburg mentioned her husband, Martin Ginsburg, as, quote, her best friend. We're sorry that he isn't going to make it here today, but we'll be in touch with him and tell him how much we appreciate his caring for our guest when we're not able to. Justice Ginsburg, you honor our podium and you grace our school. Thank you.
If I am the happiest camper, then your dean, the Honorable Howard Markey, is truly extraordinary, for he can make even the most sober judge laugh. And that's why an invitation from him was irresistible to me. I have some prepared remarks on the Supreme Court's work ways. I hope the remarks will stimulate some questions because I'd like to spend most of the time we have together in conversation with you. So let me speak first of the court's review granting process, next of oral argument, and finally of the way we reach decisions. The review granting process. It was my very good fortune, unlike my two predecessors, Justice Souter and Justice Thomas, but just like my latest colleague, Justice Breyer, to be nominated and confirmed in the summer, in August, so that I could prepare for the late September conference, the conference at which the court disposes of all the petitions for review that have accumulated over the summer recess. No person other than the 9 justices enter the room when the court is conferring, and for that reason, the junior justice has special assignments. No, I did not serve coffee or tea. We recess for refreshments. The chief orders them, and he uses a special fund to which we all contribute. But the junior justice does answer the telephone, open the door, and most daunting of all chores, she transmits the orders of the day to the entourage from the clerk's office that fills the room when the conference ends. Numbers will explain why that record-keeping job is fearsome for a newcomer. At last year's opening conference on September 26th, the court had over 1,600 petitions for cert to dispose of. In season, we confer generally at 1 or 2 week intervals, and at those conferences, the number of petitions run in the few hundreds range. Typically, we will grant, or we will put on the discuss list, only about 10 to 13% of all of the petitions for review. And then we will, on that 10 to 13%, either grant, deny, hold, vacate, or call for the views of the Solicitor General. The rest of them, the petitions that no justice asked to have discussed, will be denied automatically. My anxiety when I entered that first conference was a feeling that some of you have encountered when you took your first set of law school exams. Justice Thomas was by then a veteran, and he helped me get the votes down right through the first conference and even the second conference, till I felt comfortable dealing with the chief's fast pace and capable of doing the job without help. Reviewing cert petitions is a large time consumer. It is not the breezy work that some people outside the court seem to think it is. I've heard tell that in some quarters, it's believed that the law clerks slave over their pool memoranda, and they do. Every cert petition, no matter how humble, will get a full pool memo summarizing and explaining what the petition is about. But the justices don't simply read those memos and follow the law clerk's advice. People who think they do, who think that the law clerks are making the decisions, to quote Porgy and Bess's Sport and Life, it ain't necessarily so. It's true that all of the justices except Justice Stevens are part of what we call the cert pool, but we read the law clerk's memoranda with care and with the judgment that comes from experience, and when in doubt, we check the petitions and responses ourselves, and we do whatever other homework is required to determine whether a case is cert-worthy. The court nowadays has almost total control over its docket. There are very few cases that we are obliged to hear. That's a fairly recent change. Until 1988, about 20% of the cases that the court gave full consideration to, that is, had argument and wrote decision, about 20% of those were appeal cases, mandatory jurisdiction. They're almost all gone, so our jurisdiction is almost totally discretionary. Our principal job, as we see it, is to keep federal law fairly uniform, to resolve splits that arise among federal or state tribunals over the meaning of a federal legislative, executive, or constitutional prescription. Last term was typical. About 70% of the cases that the Supreme Court decided involved splits of authority among either the federal courts of appeals or state courts of final instance. Press reports of the court's actions sometimes exaggerate the significance of a denial of certiorari, a denial of a petition for review. I read from time to time that the court approved the lower court's decision in case X, when that case didn't even show up on the court's discussed list. And I know from personal experience the disappointment that a petitioning lawyer feels when we decline to take up a case for review, even though it presents a significant question of federal law. We generally await what we call a split of authority below, not just to keep our caseload down. Returns from several other courts can enhance our understanding of the importance of an issue, the frequency in which the issue arises, the different settings, and the range of opinions on the proper resolution. One other reason why we generally wait for a split of authorities is the genuine respect that we have for the able judges on state benches and in the federal judiciary. Those judges are fallible, as all mortals are, but they strive to get it right, and generally they do. And we possess no greater wisdom. Justice Jackson stated it best about the members of the Supreme Court. We are not final because we are infallible, but we are infallible only because we are final.
Yes, that's true.
The Supreme Court, as I just said, labors long in selecting the decisions it will take up for review, but unlike the federal courts of appeals, where the litigants arrive as a matter of right, the Supreme Court spends very little energy deciding which of the cert-granted cases, which of the cases accepted for review, which ones will be argued or for how long. Dispositions without oral argument are extremely rare in the Supreme Court, and cases that are calendared for argument ordinarily get exactly half hour aside. Occasionally last term, in a relatively simple single-issue case, I recalled fondly the DC Circuit's practice of setting 10, 15, tops 20 minutes per side. But just as often, and even more fondly, I recall the indulgence accorded judges on the DC Circuit who pursued points minute upon minute beyond the allotted time. Our chief runs a tight ship, and a half hour aside is it. But in the most essential way, oral argument in the Supreme Court is what it generally is in federal and many state appellate tribunals. It is an occasion for an exchange of views about the case, a dialogue or a discussion between knowledgeable counsel and judges who have done their homework, what we call a hot bench. Some lawyers, I've been told, resent interruptions in an oral argument that they have carefully planned as a lecture. And some judges ask few questions. My colleague Justice Blackmun, for example, often tells of the advice that he was given by Justice Hugo Black in the 1970s. Harry, Justice Black, cautioned, never ask many questions from the bench. Because if you don't ask many questions, you won't ask many foolish ones. But it seems to me a waste of a lawyer's precious opportunity to use oral argument or attempt to use it just to recapitulate the briefing instead of trying to uncover what is in the decision maker's mind. Questions from the bench can give counsel a chance to satisfy the court on matters the questioner at least thinks significant and might resolve less satisfactorily without counsel's aid. Sometimes it is true, a question will be asked with persuasion of a colleague in mind, and the lawyer may sense at those times that she is being talked through, not to. Other times, the questioner may be trying to cue counsel that an argument pursued with gusto is a loser and that counsel would be well advised to move on. A counsel too intent on a prepared script may miss that kind of cue. There is, I appreciate, a difference in the dynamic of a 9-member court and a panel of 3. A conversation accommodating clarifications, interjections, even interruptions, readily managed among 4, counsel and 3 appellate judges, is less feasible among 10. And a judge at one extreme of a long 9-member bench does not always see what is going on at the other side. In particular, she may not observe that questioning is emerging or continuing several seats away. I've proved that from time to time. Though our format is not flawless, I think argument at the court generally succeeds in its mission. It more than occasionally reduces or diminishes confusion and conflict, and it gives counsel notice and a last clear chance to convince the court concerning points on which the decision may turn. As to decisions, in a typical 2-week sitting period, The court will meet each Wednesday afternoon when arguments are done, to discuss the preceding Monday's cases, and each Friday, both to dispose of accumulated petitions for review and to discuss the cases heard the preceding Tuesday and Wednesday. First thing on the Monday morning after the second Friday, the Chief Justice will circulate writing assignments that he makes when he is in the majority, and when he is not, he will convey the assignments made by the most senior judge in the majority. Sometime in the second part of this century, the court telescoped its case conferences. Justice Tom Clark wrote in 1956 that then, as in John Marshall's day, the discussion of argued cases proceeded down the line in seniority order, but the voting started with the junior justice and moved up. Between 1956 and 1971, the year Chief Justice Rehnquist began his service as an associate justice, the old way passed, views and votes merged, and a strict seniority system prevailed. The Chief Justice sometimes describes the disappointment that he felt years ago when he was the junior justice and when his significant contributions were not heeded because votes had already been cast down the line. But he reported with newfound clarity that having risen from 9th to 7th to 1st in seniority, that his idea about more of a roundtable discussion was academic, fine in the abstract, but unlikely to contribute much in practice, and at any rate doomed by the seniority system in which the senior justices thrive. Yes, last term, more than occasionally, I did detect some impatience, a high premium on brevity when the vote came round to me and there was already a clear majority for one position. But last place has its heady moments, times when the court was split down the middle and the 9th vote broke the tie. The discussion at our conferences is often spirited, more so than I anticipated, but it's rarely protracted. It will all come out in the writing. A senior justice not uncommonly comments when we have all had our say. Turning to the writing, I have been pleased by the regard my colleagues have for the label opinion of the court. They demonstrate that regard in Dear Ruth letters that respond to a circulating draft opinion. Dear Ruth letters typically read, I recommend that you add, delete, drop, revise to say, or more hopefully, I will join your opinion if you take out, put in, alter, or adjust as follows. I am comforted at such times by a remark our chief has traced to Chief Justice Hughes. Chief Justice Hughes is reputed to have said that during the 11 years he served on the Supreme Court's bench, he always tried to write his opinions logically and clearly, but if another vote was necessary to make a majority, to reach that great number 5. And the colleague insisted that certain language be put in it went, and let the law reviews figure out what it meant. There was a long time, you may know, indeed until Chief Justice Melville Fuller's 1888 to 1910 tenure, for all the years before that, when the justices did not circulate their opinions in advance among their colleagues. The opinion author in those days had a free hand. He gave his brethren no opportunity to propose changes. He could compose and publish the opinion in his own way. I would not vote for a return to those old days. I continue to aim for opinions that both get it right and keep it tight without undue digressions or decorations or distracting denunciations of colleagues with different views. And I look forward to the useful criticisms of readers of the court's opinions when I miss the mark. Last spring, I had already received one bad grade from a reviewer of Supreme Court decisions. It was a criticism of my opinions for being too short. That was a criticism, you can be sure, that did not come from a trial court judge. Well, that ends my prepared remarks about the Supreme Court's workways. And now I invite your questions and will try my best to answer them. Is there somebody who can manage, who gets called to the microphone? Or I see there's one on either side. I suppose you can just stand up and go to a microphone.
I'm at a mic, so I might as well start it off. Justice Ginsburg, some people may contend that race was a factor in the nomination of Clarence Thomas, among other factors. But if race or gender is a factor used by the president to select a Supreme Court nominee, should that nominee have an obligation to protect the interests of the group from which he was or she was selected, or the group or the political group that selected him or her?
Any justice has an obligation to do as good a job or as he or she can possibly do to serve the law and the society to the very best of his or her ability, without regard to race, religion, national origin, or gender. And that's the answer that I would give to your question.
Justice Ginsburg, I rise to ask this question, though it may be petty. It seems as very shortly when you were told to give your opinion, you were like a steed ready to take off. And somebody from the tender side issued a reprimand. Our other woman, Justice. Do you remember anything, or was that so
Yes.
much paper copy?
No, I remember it well, as does Justice O'Connor. And what both of us remarked on is the number of times the guys do it to each other and nobody notices. The paper picked that up. They said, Justice O'Connor chastised Justice Ginsburg for interrupting. And the truth was, we had lunch together that day. I apologized because I hadn't realized that she wasn't finished with her line of questions. And then we were both, at first, surprised, a little annoyed to see the press coverage of it, but then both of us recognized and made the same comment, sitting the next day and the next day, that the guys do it all the time. Watching Justice Scalia, my good friend, for example. So we've come a long way in recognizing the talent of women, but not all the way. And that's the reaction that she had to that coverage. It's the same reaction that I had. There is no reason for Justice Sandra Day O'Connor to treat me any differently than she would treat her male colleagues as far as the questions are concerned, and I don't treat her any differently in that regard. We're both
I will recognize the elasticity of a rubber band.
good. Good. Yes.
Justice Ginsburg, in today, the age of CNN and information that comes across as soon as something happens, is the court today, in your opinion, more susceptible to pressure to resolve political situations than it may have been in the past in terms of granting cert to issues which are in the public conscience but may not be ripe for judicial review otherwise?
We don't have any agenda of what cases, we don't say, oh, this is the year that we should try to straighten out the copyright law or whatever. As I said, we take cases mainly because there's this disagreement among lower courts about what the content of federal law is. And our job is to see that federal law is not one thing in Illinois and a different thing in California. So that's when we step in, and it doesn't have so much to do with the subject area as the existence of a division, of a sharp division. Now, there are some issues where there is no point in waiting for many returns because you know that that's going to be a repeating issue and it's one that should be settled. One such example on the court's current term, in the court will hear this term, is the term limits for members of the legislature. Now that we will hear and decide that question this term, but for the most part, overwhelmingly, we take cases when the courts, the lower courts, are divided on what federal law means.
Justice Ginsburg, you've been very frank in telling us some of the details, as all judges and lawyers like to learn. What about the solitude question that you encounter as a member of the Supreme Court versus your previous situation? Is there a difference?
First, the difference of being a judge on any bench. It was not such a large difference for me because I spent most of my life as a law teacher, and the idea of having an encounter with people in a class and then going back to your office where you are alone with your typewriter, or nowadays your PC, or and reading, thinking, and writing. Carl McGowan, who was probably the finest judge I ever served with, said,
Chicagoan.
yes, he said that law teaching and judging are more alike than any other two ways of working at the law. And I think he was right in that respect. The enormous difference that the Supreme Court makes to a judge's life is not the preparation for oral argument, reading briefs, writing opinions. That routine is very much the same as the one I had on the DC circuit. It's the publicity of your life. When you go out of doors, things are not the same. Everything I do is noticed. If I go to the movies and I take out my flashlight to read my mail during the previews, that gets written up in the Washington Post. And then within the month, I receive a half dozen pocket flashlights from caring people all across the country.
Thank you very much, Justice Ginsburg.
There's been many attempts to equalize public funding for education. I was wondering if you foresee this happening in the future, and if so, under what legal basis?
Well, my guess on that question is as good as anyone else's in this audience. If it is something that will come before the court, then I can only give you the same answer I gave to the Senate committee last year. And I know that I'm not in print on that issue, so I think I'd better await the day when the occasion arises for me to be in print.
Thank you.
Justice Ginsburg, Justice Ginsburg, how do members of the court respond to friend of the court briefs or react to them? First question. And second question, slightly more procedural. What is the procedure when the court addresses, or what would be the procedure when the court addresses a case that is comes under the Supreme Court's original jurisdiction?
In most cases under our original jurisdiction, we have a master appointed by the court who prepares the case up to the point where, and even has a recommended decision. That would be typical in, say, a boundary dispute between two states. We don't get more than one or two of those a year. And the justices start out first by accepting the case and then by sometimes discussing at some length what lawyer would be most appropriate to be assigned the master of that, as the master for that case. That was your second question. And your first question was about, well, there are friends and there are friends. There are some very good friends. And there are some who are frankly just impressing their clients. And it can be pretty annoying when you have, the briefs in the Supreme Court come in colors. So the petitioner is blue and the respondent is red. And the amici are either light green or dark green, depending on whether they're supporting the petitioner or the respondent. You pick up a brief and read the same thing that you have read in the petitioner's brief or in two other amici brief. It can be very annoying, and if you want to know the truth about how those are handled in my chambers, and it's not different, very different in others, my clerks will look at the green briefs. I will read every main brief, every word of it myself, but the green briefs, my clerks will tell me, this is one you can skip. This is one you should read these pages, and that's the only thing that's different in this brief. Or this one makes a major contribution, and you should read the whole thing.
Thank you.
Justice Ginsburg, excluding those who are presently on the court, would you care to indicate what justice or justices may set an example, influence you, or their style, their person, their decisions that you would consider to be something you would want to emulate, influence you? In other words, historically speaking, who are your favorites?
It's like asking a mother to pick out her favorite child, but there are so many, and by mentioning a few, I don't want you to think that there aren't others, but certainly Justice Holmes for his beautiful writing and his economy. Justice Cardozo and Brandeis for the tremendous restraint that they showed in not publishing opinions that they had written and circulated, and their willingness to withdraw a separate position so that the court could come out unanimous or close to that point. The collegiality that shows. Well, that's a pretty good group, I think.
Thank you.
I wonder if you could tell us a little bit about the process and maybe some of the factors you take into account when you choose law clerks.
Recommendations of faculty colleagues that I trust. That above everything else. Second, good writing. Before I make a final selection of a law clerk, I will always read the writing sample myself. And third, someone who will work well in chambers. Someone who is considerate. I've often said that law clerks are wonderful and they're great assistants, but the people that I rely on day in and day out are my secretaries. My secretaries came with me from the DC Circuit to the Court of Appeals. And this job has been as overwhelming for them as it was for me this first year, and they're simply wonderful in the devotion and the care that they take. Yes.
Ginsburg, as a lawyer, you were a voice for the voice. Put your head to the wind and fought against discrimination. We have some wonderful law students here. What advice would you give them as they go forth from John Marshall to the world to practice law?
Well, one is, don't be discouraged by a no answer or a closed door. Just take it as a challenge, something that you will have to work hard to overcome. And often you can take a rejection as an opportunity to teach somebody else something that they may not know. In my days, so many times I was told by a potential employer, oh, we had a lady lawyer once and she was dreadful. So, who'd like to ask, and how many male lawyers have you had that turned out to be dreadful? One important thing is not to get angry and lose your temper, but to keep your cool, keep your sense of humor.
Maybe I'll ask my question first. I think it's brief. You mentioned 1,600 petitions that accumulated over the summer. And I've heard commentators, politicians, and some judges say that there are growing numbers of lawyers in the United States. Do you know historically if those numbers of petitions have increased from year to year? And is there a reasonable expectation that they will continue and become a real burden for management of the court's time?
I can tell you what the numbers are, and some of you may find this surprising. I know I did. The court divides its cases into the paid docket and the IFP, the informal pauperis, the unpaid cases. The petitions on the paid side have stayed remarkably constant for 2 decades, hovering around the 2,000 mark. Last year we had 2,100 petitions on the paid side. They have simply skyrocketed on the IFP side. Many of those are prisoners' petitions, but they've gone from 1988 to 1994 from something from about around 2,500 to about over 4,700. So there's been an enormous increase in the IFP filings, but for 20 years, from the early 70s, a fairly constant number of paid petitions. Now,
Could I ask you if that's because they're self-ordained healers? There's a lot.
well, we've had, if you had to take one category of those, the largest category, I think, would be the sentencing guidelines challenges. And the court seldom grants any of those cases because the Sentencing Commission has done a pretty good job of, when there's a disagreement about what a guideline means, to take it up for consideration and revision. So, but many of those, the ones that we've seen lately, just a tremendous number of guideline cases. And it may be the increase in the prison population too. Both the number of people in prison and the length of their sentences.
Justice Ginsburg, as a professor of constitutional law approximately 3 times a week, I met with one version or another of, but they'll decide what they want to. Could you please perhaps help me assist my constitutional law students in deciding what kinds of argument in the most generic sense make for persuasive constitutional argument?
But the best argument, as I tried to explain, is an attorney who will invite a dialogue with the court. Somebody who is not intent on giving the court a lecture. You could compare it to a seminar in a law school. Somebody who has a conversational tone, who's there to increase the court's understanding of what the case is about. We've had some remarkably good appellate advocates in the court this year and some that were not so good. But it's mostly the people who are going together with the court and are not resisting questions, are not trying just to, sometimes you can see a lawyer who doesn't want to be interrupted and will just try to talk so fast so that there won't be any point at which that person can be interrupted. And one of the most annoying things is the lawyer who continues talking when the judge asks a question. And that should be your first rule, would stop talking when the judge starts.
Justice Ginsburg?
Yeah.
First of all, I'd like to thank you for your visit here. I'm struck by the historical nature of it and would like to thank you, and we're all honored by your visit. My question is, perhaps it's due to the baseball strike or the Simpson trial, but lately the law and trials particularly have become the nation's greatest spectator sport. And I know that there are now tapes of famous oral arguments that were given before the court that are available. If it could be done in a non-obtrusive manner, do you feel that broadcasting, televising the oral arguments would have a beneficial effect on both the reputation of the legal community and as well as an educational effect for the country to see what the issues of the day, how the issues of the day are being debated? And
well, first let me say on the question of the tapes, the audio tapes of oral argument are now available to any member of the public without any restrictions. I think it took the incident that occurred last summer to make the court aware of a policy that most of us didn't even know there was. So now those tapes are available to anyone who wants to go and listen to them. There's an experiment going on now. Your dean may know more about it than I do. In other federal courts, both trial courts and courts of appeals, of televising trials. And I think a report will be made to the U.S. Judicial Conference, if not at this September meeting, then at the next one, on how that experiment is going. And all of the people who are concerned about televising proceedings will follow that report with great interest, and the U.S. Judicial Conference will make a recommendation whether the experiment should be spread further, whether it should be terminated. One concern you can understand, it's apparent, it's gavel-to-gavel coverage is one thing. Another is for a court to surrender a videotape to someone who will edit it, as that editor will, and you could give a very distorted picture of what goes on by the way you put things together. But that's a very important topic right now, and this study has been going on for a couple of years, and I'm going to read that report with great interest.
are you personally in favor of having that type of access?
Well, as I said, if it can be done gavel to gavel, so that there's no risk of distortion, so it's the court's own product, then I think it can be a useful tool. I know as a teacher, I would have found that kind of thing very valuable. But I would, of course, respect the views of colleagues who might be discomforted by it, and will read with great interest what the lawyers tell us about their reactions to it and the reactions of their clients and of witnesses and of jurors. So my mind has not yet come to rest on the question, but those are the various things considerations that I would give weight to.
Thank you.
Justice Ginsburg, Chicago and other major metropolitan cities are currently facing some severe sociological issues such as relocation of public housing and unprecedented levels of deadly violence in projects in other neighborhoods. In your view, absent express authority in the U.S. Constitution or in a valid controlling statute, what should be the Supreme Court's future role, if any, in matters concerning desegregation, busing, and public housing as manifested through the federal judiciary?
I tried to explain in my talk that the Supreme Court has no agenda to set. We're not a legislature, and we're not an administration that has a program. We are the court that settles disputes about the content of federal law. And we don't pick the issues that we want to. There's no consensus that this is the time for the Fourth Amendment as opposed to the Fifth Amendment or the First Amendment. We genuinely concentrate on what issues are dividing the lower courts. How can we make federal law fairly uniform throughout the nation? And so it would be just as important to us, say, if there were a provision of the tax code that allowed, say, a deduction in one circuit and not in another. That would be an instance of disparate treatment of similarly situated people that would lead the court to. We are not like the Supreme Court of a state. We hear just a tiny percentage of the controversies that come up in the country. And I can't emphasize that strongly enough, that the role of the United States Supreme Court is to keep federal law uniform throughout the nation.
Justice Ginsburg, the Hawaii legislature has recently ordered the lower courts of Hawaii to ignore the Hawaii Supreme Court decision in Bear versus Lewin. That was the decision which authorized same-sex marriage in Hawaii. I would like to know what your view is on that position as far as what the legislature has done. In addition to that, I would like to know what your position is on the state's right to regulate marriage in the sense to prohibit same-sex marriage and what you would justify the basis of your reasoning on.
First, I can't comment on the Hawaii decision because I'm not at all familiar with any of the decisions the Hawaii Supreme Court or the District Court in Hawaii. Although I can tell you I had a delightful time in the District Court in Hawaii. I met with all of the judges and the law clerks there. They didn't, just in the beginning of August, they didn't mention this. And on the other, then you must know that that a question that is likely to come before the court on which I am not in print, I will not address. It would be inappropriate for me to do so.
Justice Ginsburg, in some areas, particularly in fair housing, for example, over the last period of time, some people have counseled not to go to the Supreme Court because of some perception as to how they would handle issues like fair housing issues. I take it from your answer, perhaps, I'll ask the question, should that be a consideration in deciding which cases to take to the Supreme Court?
By the time the case gets to the Supreme Court, the court is pretty well informed because it's gone through a state system, 2 or 3 tiers, another system that gave rise to a complex. So this court is extremely well informed when it decides an issue. It's a judgment a lawyer has to make. If you can, I know when I wrote briefs for the Supreme Court, you had a special luxury that you don't have in many lower courts. That is, you know who you're writing for. So when I was a brief writer, I always wrote for the justices that I thought might be uncertain. The ones that I knew would rule against me, I didn't try to persuade those justices. The ones that I knew would vote for me, I didn't need to try to get their votes. But I always argued for the ones that I regarded as the swing judges. Something else about the Supreme Court that's very nice from a judge's point of view is the cases are much neater than they are in the trial court or in the Court of Appeals, where there may be a lot of issues and rather messy records. But the Supreme Court grants cert on 1 or 2 questions, and that's all the lawyers can argue. And everything is finally honed down to that 1 or 2 issues. I don't know that I can give a better answer than the one I did.
Thank you.
Justice Ginsburg, you mentioned earlier that women have come a long way in the profession of law. In your eyes, what would be coming all the way? And do you foresee that in the near future?
The day that men take equal responsibility for raising children, that will be the day that women have gone all the way.
Justice Ginsburg, this is in some ways a follow-up question to that. Without trying to ask you to answer what is your personal opinion about the long ago defeated Equal Rights Amendment, without asking you what your personal feelings are about that, as a matter of constitutional law, would you say that, would you agree with some of the opponents of the ERA who said that it really was redundant and was not constitutionally necessary because of the protections of the Equal Protection Clause? Or would you say that it would have made a substantive difference as far as equal protection on basis of gender?
It isn't a question of opponents. Martha Griffiths, who was one of the leading proponents of the Equal Rights Amendment, said there never was a time when Supreme Court decisions could not have done everything that we're hoping to achieve with this Equal Rights Amendment. It just hadn't happened. When the Senate sent the Equal Rights Amendment out to the states, there hadn't been any case that ever declared any gender line unconstitutional. But there were decisions, even from the, quote, liberal Warren Court, that said it was all right for example, the state of Florida not to put women on juries, because after all, they were the center of home and family life. The Supreme Court didn't begin to apply the Equal Protection Clause to strike down arbitrary differentiations based on gender until 1971. That was the first year. And there was always a view that once the 19th Amendment was passed and it made women full citizens, that was in effect an Equal Rights Amendment. Women were always citizens. They were always people within the meaning of the Equal Protection Clause. They were always citizens, but they didn't have the most basic right of citizenship, the right to vote, until 1920. So many people thought that You just put the 14th Amendment together with the 19th Amendment, and that's essentially the Equal Rights Amendment. But it didn't happen. And then we were part of a world in which human rights became very important after World War II. And every modern human rights document, every constitution written since World War II, every UN human rights declaration does have the equivalent of an Equal Rights Amendment, a statement that men and women are equal before the law, or persons of equal stature and dignity. So we look, it's kind of embarrassing for me to talk about the United States and how wonderful its record is in human rights compared to other countries when Afghanistan can point to a beautiful Equal Rights Amendment in their constitution. The United States has none. That's a long answer to your question.
Justice Ginsburg, you pointed out that the role of the Supreme Court is to clear up any disagreements or any confusion, say, between different federal tribunals or the high courts of different states over particular issues. I'm curious as to what your opinion is then in reference to when the Supreme Court issues a plurality opinion that in effect demonstrates a difference of opinion or a lack of resolve of a particular issue amongst the 9 jurists itself.
It's unfortunate. We all regard it as unfortunate and try hard to avoid it. It didn't happen too many times last term. I think there were fewer opinions of the kind that law professors love to make fun of, that was so-and-so delivered an opinion for the court on issues 3A and 6B. No, we didn't have too many. We try, but we don't always succeed. And particularly at the end of the term, I had never appreciated what that June blizzard was. One thing is very good about the system, that is every case that gets argued must be decided before we recess at the end of June. But the number of opinions that are in circulation in the last 6 weeks of the term makes it very difficult to do as much accommodating and adjusting to avoid the badly splintered decisions. Nobody thinks it's a good thing, and we do try to avoid it.
Would you care to comment on the briefs you receive? Are they of the quality they should be, and what advice could you give lawyers in preparing briefs?
On the whole, the quality is very good, and I've noticed, particularly in representatives of states and municipalities. There are a couple of organizations that help with those briefs. I forgot their names, but they're very good. And so we get a rather high quality of from governments at all levels. On the side of the United States, the Solicitor General has a high quality standard, but also if I could compare how it was in the 70s when I was sometimes litigating against a state or municipality, the briefs that we get nowadays are much better than the ones that I was facing when I was writing the brief on the other side. And then, as I mentioned before, we do have a lot of friends, and sometimes those briefs are wonderful. The court very often will invite the Solicitor General to express the views on behalf of the United States. At the request stage, sometimes when the court is not certain whether a question is worthy, we will call for the views of the Solicitor General, and the solicitor will file a brief saying whether the government recommends taking or not taking a case. And in many cases, we get that once we do take them, we get the government filing in support of one side or the other, and the quality of those are very high. Quality counts in this sense. In many cases, when we grant cert, there will be what we call hold fors, that is, many cases raising that same issue. We will grant cert to the petition that looks to us like it has the best lawyers. And I've noticed a number of times we did that last year, where we'll hold the case that doesn't, with the cert petition, the brief in opposition are not that impressive, and we will give cert to the case that has good briefing. At least we can predict good briefing from the quality of the cert petition and the brief in opposition.
Do you want to take a rest?
Well, let's see. We could. Why don't I take just a few more?
Justice Ginsburg?
Over an hour.
Okay.
I'll make my question short.
Why don't we say three more? How's that? Okay.
Great. As a follow-up to Professor Corker's question concerning clerkships, what would I need to do as a Marshall grad in '96? What career path would I need to follow to become a Supreme Court clerk?
Most of the clerks on the court have clerked either in a district court or in a court of appeals. And that's very important because I said I rely on the recommendation of my academic colleagues, also on my colleagues on the bench. If someone is an excellent clerk, that judge will tell me. So what can I say? Do well in law school, write, become a good writer, get a good clerkship, and do a good job.
Okay, thank you.
Hi, Justice Ginsburg. I know that you said that the court as a group doesn't form an agenda. I'm curious, though, about the ways that the decisions are made by the individual justices who do ask for a particular case which has been presented for review to be considered. I think you said that those that weren't promoted by an individual justice would fall and die. Other than the fact that the decision to put one up would be based on a feeling that there was some unresolved important federal question, would there ever be any pattern that you've noted that some justices may have showing a preference for certain types of issues or problems that would also then be put before the court, as well as the decision having been based on some underlying federal question?
I don't think that any of my colleagues have an agenda of let's take this kind of case or that kind of case. One reason is it won't work, because if each justice decides that he is going to be a prima donna, a prime don, and this is what he's going to push, then the others will have other favorite issues. There is one large exception to, we don't discuss a case unless any one justice can put it on the list. Takes 4 to grant a petition. Every death case is automatically on the discuss list, no matter what stage it is at, whether it's a direct appeal, whether it's state habeas, whether it's federal habeas. And those death penalty cases take a tremendous amount of time, of the court's time. There's one person in the clerk's office, very able lawyer, who does nothing but handle the death penalty cases. We will get, at the beginning of every month, a list of the executions scheduled across the country that month, and each chambers will have one law clerk assigned to be on a usually 48-hour vigil as you approach the final moment in those cases. So that is the one category of case that is always discussed, that's always on our agenda.
And I know I'm here for seconds, but I did have one question that intrigues me a lot. Justice Ginsburg, in the, I believe it was Harris versus Forklift case that you decided last year, one of the issues that was involved was the issue of the reasonable person standard. And of course, some argue that reasonable person in the past is really just relabeling reasonable man. And there have been lots of calls, especially in legal literature now, for developing a reasonable woman standard, for acknowledging that in some situations men and women do see a situation differently. That what a reasonable man would assume is not what a reasonable woman might assume. I was a little unclear how the court, what the court did decide on, or if anything, on that particular issue, and in particular your views on that.
I thought the standard was reasonable person similarly situated. Who are the tort students around here? Isn't that reasonable person similarly situated? And I smile because it was a great philosopher who said those who fail to learn the lessons of history are condemned to repeat it. There was once in this country a reasonable woman's standard. It persisted, I think, into the current century. And it went like this. If there was an accident on a train, someone stepping off a train and tripped and fell, if that person was a woman, she didn't meet the reasonable woman standard. A reasonable woman is more careful than a boisterous male. So if she tripped and fell, probably she wasn't a reasonable woman, where if the man went headlong. So we did have a reasonable woman standard in this country. It was used to reduce the occasions on which women were able to recover. People who remember those bad old days are a little leery about returning to such a standard.
So do I take it that your approach may be to treat the reasonable person standard as a contextual standard rather than an abstract?
I thought the standard was reasonable person similarly situated.
Which would be contextualized, yeah. Okay, thank you.
I think is that our third question? Well, it's good to be with all of you.